All rise.
Welcome to the Irish Courts podcast. This is our first series, where we explore seminal cases and key moments in the evolution of the Irish court system. In this episode, we explore two district court cases. These two cases started small but established fundamental universal practices of how justice is achieved in criminal trials.
It's about making rights real. Having a lawyer is not a luxury, it's a right.
The first of the cases is Healy versus Donoghue, initially a small case brought about by a mother looking for justice for her son, who was accused of maliciously damaging a car. This case went on to establish our constitutional right to legal aid in criminal cases and establish the obligation on the court to inform an accused person of their right to apply for representation. The case began in 1974 with a law student who is now a retired judge of the Supreme Court, John MacMenamin.
There's a background to it. And the background starts with a friend of mine, Dara Hogan, who lent me a book. And the book was called Gideon's Trumpet. And Gideon's Trumpet was a book written by a guy called Anthony Lewis about a case which happened in the United States Supreme Court in 1963. And that case was called Gideon versus Wainwright. And in that case, the Supreme Court of the United States held that there was a right to legal representation as part of the due process provisions of the US Constitution. Due process means that a trial should take place in the due course of law. And I read this book and I was fascinated by it because it was all about a guy called Gideon, and he was tried in Florida, in Panama City in Florida, for robbing a pool hall. And he said at the beginning that he was entitled to legal representation, and the judge said, no, sorry. And then after that, the Supreme Court of Florida said, no, you're not entitled to that. But he petitioned the Supreme Court of the United States, who had been previously thinking of legal representation and had made decisions back to the 1930s on it. And then they delivered a great judgment, which was called Gideon versus Wainwright. And it held that people were entitled to legal aid and advice when they were being tried for criminal cases before the courts. So I read this book and I said, that's fascinating. And then I was in FLAC Centre in Ballyfermot. FLAC was an organisation set up by 4 people in 1969. It was designed and intended to give people legal advice, and young solicitors and young barristers joined this organisation, pledged themselves to do work for nothing, pro bono, and it mainly dealt with family law cases. At that stage, family law was very, very poorly developed, and women were left very frequently in a situation where they were deserted and found it extremely difficult to get any maintenance. That was the main business of FLAC. I was still a law student, so I was very much wet behind the ears. And a woman called Mrs. Foran came in one day, and she was very distressed because her son, Anthony Foran, had been arrested and he was going to be tried for malicious damage of a car. At the time, there was a legal aid strike. He had been assigned a solicitor. The question arose and would arise as to whether the solicitor would turn up. I can still actually see the room in the community centre, see the desk that I was sitting at, and see her coming in and me saying, gosh, is this going to be a situation where he's going to be convicted without a legal advisor? And I thought back to the case, Gideon versus Wainwright, and I said, gosh, I wonder what will happen. So I went to the court on the day. The lawyer never turned up, and the case just went ahead. It was in that context that the case went ahead in Rathfarnham District Court, and Anthony Foran was tried and he was sentenced to prison, along with another co-accused called Healy, John Healy.
These two boys, aged 16 and 18, who had no legal representation in court, spent 7 weeks in custody from the 13th of December 1974 to the 7th of February 1975. which meant they spent Christmas in custody. Anthony Foran also spent his 17th birthday detained as he could not obtain the bail that had been set. Anthony was convicted and sentenced to 12 months detention the day after his 17th birthday.
Different times. It was shocking, but it quite frequently happened in the district court, where the judges took the view then that it was a court of summary jurisdiction and they would dispense justice. But sometimes it meant that justice was not administered at all. Could be very unfair. Very unfair. And as the United States Supreme Court said in Gideon, having a lawyer is not a luxury, it's a right. So this book that I'd read, Gideon's Trumpet, came back into my mind, and I said, I'm going to talk to my friend Frank Clarke, who I'd known for an infinity of time before then, going back, I think, to the time we were 16 or 17. And we used to go out to Belfield together on the 17 bus, sometimes not as early as we should have for the lectures. I went down to the law library, and Frank, at that stage, I think, Frank, you were in your second year, so he was out of Devling. And I called him to the door of the library and said, Frank, could I talk to you about this case? So I described what had happened. From then on, things proceeded. He got Urquhart Stewart, I think, first. I remember him going down to the law library and asking Urquhart to come and talk to us. And Urquhart came and spoke to us. And then, I think a little bit later, Frank...
This is Frank Clarke, retired Judge of the Supreme Court and former Chief Justice.
Rory O'Hanlon, who was subsequently a significant High Court judge, but also at that time, as well as being a top senior counsel, was Professor of Constitutional Law in UCD, and it actually, I think, taught me and probably taught you as well, constitutional law. And he came in to do the case, to lead the case. And Brian Gallagher had been a leading figure in setting up Flax as a solicitor, so he came on board as the solicitor in the case. So we assembled that team of Brian Gallagher as solicitor, myself, Urquhart Stewart and Rory O'Hanlon to do the case. And in fact what happened first was we first brought a case on behalf of Anthony Foran. And that case was relatively straightforward, just as John has described. He had been given legal aid, but the case went ahead without the legal aid. And indeed, at the time, the way in which you got legal aid was the district judge had to certify that you needed legal aid in the interest of justice. So in a way, that was a kind of relatively straightforward case. You said there was a certificate saying you need legal aid in the interest of justice. The case went on without it, so that's not right. There was no law that said that the case couldn't go ahead. There was no entitlement to legal aid as such. You could apply for it, and if you were given it, then you were meant to get a solicitor. So in a way, it was a narrower case for Anthony Foran. It was just, you did apply for it, you were told you were getting it, and then the case went ahead without it. Because, as John said, John Healy was also a co-accused. He was joined to the ticket, as it were. So we brought a second case on his behalf, which was the same case. He'd been given legal aid, case went ahead without legal aid. But then, as often happens in the real world of litigation, a quirk emerged. The procedure in those days, it's slightly different now, but the procedure in those days was that the state put in their case, as it were, explained why someone was in prison. And it emerged that in the case of John Healy, he was in prison on 2 convictions. One, the one he'd had jointly with Anthony Foran, but a second one on a different occasion where he hadn't applied for legal aid at all, but the case had just gone ahead. So that became a more complicated case, and the one which probably is legally a lot more significant, because there we had to argue not just that it was wrong for a case where someone had been given legal aid to go ahead without the legal aid, but rather that there was an obligation on the district judge to ascertain whether somebody ought to get legal aid. And that was the more elaborate case. So all 3 cases then ran together. They all ran in the High Court before Judge Sean Gannon. We actually won the 2 simple cases, the cases where they had been given legal aid, but the case went ahead without it. We lost in the High Court on the 3rd case, which was the case where we were making the bigger constitutional argument, where we placed a lot of reliance on the American case law that John has mentioned. And therefore, we appealed the one we'd lost to the Supreme Court. The state appealed the two they had lost to the Supreme Court. So all three cases went to the Supreme Court. So these were all cases where we were seeking what's called certiorari. And certiorari is an order where the High Court or higher courts on appeal can make an order quashing a decision of a lower court, or indeed other outside court bodies, administrative bodies and the like, on the grounds that it's unlawfully made. So what we were seeking in each of the three cases was a quashing of the conviction order because of the absence of legal aid. All three went to the Supreme Court, and we upheld the High Court decision in the two we'd won, but most importantly, perhaps, we won the case that we'd lost in the High Court when the case went to the Supreme Court.
It was a very forbidding thing for young people like you and me to be appearing before that Supreme Court, because there were these godlike figures who we looked up to and said, my God, there's Chief Justice O'Higgins, Mr. Justice Henchy, and the whole array of super-duper judges. And one of my primary jobs, I remember it vividly in the Supreme Court, is our two clients were sitting in the back of the court and they'd had a hard night the night before. And the only sounds that could be heard from the back bench was the two of them quietly snoring as the case went on before the Supreme Court. And my job was to give them a dig every so often and say, sit up and pay attention. This is legal history being made here. and it's a very vivid recollection because I can still see their faces, not necessarily paying great attention to the very learned arguments which were going on in the court. And, well, then we won. Thanks to the great barristers who were appearing and to Brian Gallagher, who undertook all the work.
For someone who was only in their second or third year at the bar, it was just quite extraordinary to be in a case of that complexity and importance. And it was really a wonderful experience from my point of view. And it did have very profound effects because it meant that the Supreme Court held. The phrase in the Irish Constitution is in due course of law. The phrase in the American Constitution is due process. But the concepts are sort of similar. And one of the key issues is, does that just mean technically complying with the rules, as it were, or does it include a bigger issue of the case being justly handled, if you like? And what the US Supreme Court had held in Gideon was that the due process requirement in the US Constitution carried with it an obligation of that kind of basic justice, if you like, that the case had to be justly dealt with. And we argued successfully before the Irish Supreme Court that the due course of law phrase in the Irish Constitution had a similar meaning. I suppose at the most mundane level, the orders were quashed. At a medium level, it led to the fact that there was an obligation now in every case on the judge taking the case to ascertain whether legal aid was necessary and to give it if it was necessary, which meant that legal aid was now being applied in a very large number of cases as opposed to only a small number. And perhaps at an even bigger level, it established that very important constitutional principle that due course of law doesn't just mean technically complying with the rules, that it has a sort of an overriding requirement that the process be just and fair.
Yeah, it's about making rights real. The other interesting thing about Healy, I think, is the court said this is a constitutional right. And therefore, it wasn't a question of having to say, well, we'll make out a business case for it. It was something the Constitution demanded. That was it. The government had to comply and did eventually.
I mean, the point I was making about it having wider implications than just technical compliance with the rules is, I think, encapsulated by what the court said when it said the concept of justice, which is specifically referred to in the preamble to the Constitution in relation to the freedom and dignity of the individual, appears again in the provisions of Article 34, which deals with the courts. It is justice which is to be administered in the courts, and this concept of justice must import not only fairness and fair procedures, but also regard to the dignity of the individual. No court under the Constitution has jurisdiction to act contrary to justice. And I think that encapsulates, I suppose, the broad principle which the court was identifying, that the requirement of justice isn't just complying with rules. It requires basic fairness and dignity for those involved in the court system. And I think that finding has had implications across a whole range of different areas.
The whole idea encapsulated in that passage that Frank has referred to, it is justice which is to be administered in the courts. And this concept of justice must impose not only fairness and fair procedures, but also regard to the dignity of the individual. No court under the Constitution has jurisdiction to act contrary to justice. This is particularly true if the absence of legal aid is compounded by factors such as a grave or complex charge, or ignorance, illiteracy, immaturity, or other complex matters, rendering the accused incompetent to cope properly with the prosecution, or any inability because of detention and restraint to find and produce any witnesses, or simply the fumbling incompetence that may occur when an accused person is precipitating into the public glare of an alien and complex court. They're very stirring words, and they really do deal with the idea of a living constitution. The court there was talking about how we should see a constitution and how it should be interpreted as a living document. The passage that we've just referred to is actually quite significant, but it was an interesting reiteration in the mid-1970s of how constitutions should be interpreted. The duties on courts and the duties of judges to ensure that it is justice that is administered in the courts, not just the simple letter of the law.
And it's a small world story because one of my jobs at the moment is chairing the government's civil legal aid review. So having started my career as a barrister involved in a major case about criminal legal aid, I'm now post-judicial career actually involved in civil legal aid.
And the other funny sequel was the guy who went down to the young barrister in the forecourts outside the law library, and we ended up sitting beside each other in the Supreme Court 45 years later.
We were both appointed to the High Court on the same day, and we were both promoted to the Supreme Court on the same day. So it's
doppelgangers.
The second district court case, which further advanced our legal rights, is the Gary Doyle case. A case that also highlights the importance of representation, a legal right which was established in the Healy versus Donoghue case.
Gary Doyle is perhaps the most mentioned case in the criminal courts, and to the extent that you'll hear the words Gary Doyle mentioned in every district court in the land every day.
This is Senior Counsel James Dwyer. The case is referenced every day by the request for a Gary Doyle order. Aileen Donnelly, Judge of the Supreme Court, who in 1992 was Gary Doyle's barrister.
You would seek maybe a Gary Doyle order by sending a Gary Doyle letter, but the order is an order from a district judge directed to the prosecution to tell the prosecution that they must hand over statements or reports that they're going to rely upon in evidence in a trial in the district court. If any statements or reports in their possession, they have to give information about the evidence that they are going to call in the district court.
It is a huge case and it has huge consequences because it deals with the knotty issue of disclosure.
If Gary Doyle had elected for a trial in the circuit court, he would have been entitled to the relevant disclosure contained in the book of evidence. This includes statements and reports. However, the risk in seeking a trial in the circuit court is that he could potentially receive a significantly higher sentence than if he went to the district court. In general, the sentencing power of the district court is limited to a maximum of 2 years. However, for example, in burglary offences in the circuit court, it could be up to 14 years. The Gary Doyle case established the accused's right to be provided with the prosecution evidence in the district court.
What happened was young Gary Doyle, who was only 16 at the time, was charged with 4 offences of burglary or attempted burglary of a garden shed in Dublin. And as he was a juvenile at that time, he appeared in the children's court. His solicitor, Mr. Polo Moraku, wrote a letter seeking information about the charges. And what was sent back was a statement which was a confession that he was supposed to have made before the Gardaí, but no other information. And the Gardaí said that they hadn't got any further witness statements and that was all there was.
The police say to his solicitor, Mr. Amuraku. The police said, well, we have your own client's confession. We'll give you a copy of that. We haven't bothered to interview any of the injured parties. We've talked to them, but we didn't take notes of our conversations with them. Now, that was 1992. The notion that that would happen in a modern policing context is extraordinary.
There is all sorts of statutory requirements as to what's called a book of evidence. We've probably all heard of that, but you're only entitled to that if your case is going for trial by jury.
If Gary Doyle had said, I want a jury, he would have gone to the circuit court, would have got a book of evidence listing the witnesses, and those witnesses would have had to have made statements, and he would have been able to read that book of evidence and his lawyer read it and analyse and look at the case against him and consider it. So, and the Oireachtas is provided for that in the Criminal Procedure Act 1967, and this arises from the right to an accused person to go into court and to know what he's charged with and what the evidence will be against him, so that it isn't withheld in an unfair fashion. And he's also entitled, in the normal course, to copies of the fruits of the police investigation. So if you're charged with robbery and the prosecution produce one witness that says, I know that it's you, I saw you committing the robbery, you're also entitled to access to the fact that the police have interviewed 9 other people that said, well, I think it was somebody else. It's a double thing. It's an entitlement to know what the case is against you and also to have access to the police investigation.
Exactly. And the reason why you want information is also to be able to advise a client as to whether they might consider pleading guilty or not guilty. It's a wider idea of gathering information to be able to give them the best possible advice in the circumstances. It's not always for ensuring that you can contest a trial, but if you have to contest a trial, you should have all the information, and you should have all the information before you're giving the person the legal advice that they're entitled to. It seems almost unbelievable now that somebody can go on trial where in particular they're risking going to prison without actually knowing in advance the evidence that is going to be put in front of a judge on which they may be convicted and sentenced to prison. I mean, that just seems astounding.
And a book of evidence is where the prosecution in a trial on indictment will say, here are the witnesses that are going to give evidence, and here are their statements, and here are the exhibits to which you have a right to see. But when you go into the district court, you've none of that. And I remember on occasion going into the district court, and you'd walk into court, briefed to defend somebody, you knew his name, and very often you didn't even know what he was charged with. And you're going in on the blind. And I do remember cross-examining a guard once, saying, do you have the charge sheet with you? And the guard is wondering, am I making some strange procedural point? I said, can I see the charge sheet? He says, yeah. And I'm looking at the charge sheet, and I, for the first time, realised the charge that my client is charged with. Now, that didn't happen very often, but this is the kind of seat-of-your-pants type of stuff in the district court compared to trial and indictment, where you have this book of evidence, you have all this disclosure and all that sort of stuff. It's not without its controversies. At the moment, there's a big issue in disclosure whereby victims of sexual crimes are often the subject matter of very invasive disclosure requests. That can be something where the courts have to balance up the difficult issues of privacy on the one hand and an accused's right to a fair trial on the other, and it's a very difficult issue. So going back to Gary Doyle,
I was asked to go along to the juvenile court and make an argument saying that in this particular case, we should have more information about what the people were saying had taken place in relation to the thefts from their garden sheds. And I argued the case in front of a Judge James Paul MacDonald of the District Court. The background to this was really that in 1981, there was a case called Clune and the DPP, where one judge had said there isn't a general right to have disclosure of documents when you're having what's called a summary trial. A summary trial is a trial in the district court by a judge sitting alone. You aren't generally entitled to the kind of information and documentation that you would get if you were having a trial before a jury. So then in 1991, there was another case called Cowser and Judge Kirby, where a different judge of the High Court, Mr. Justice Barr, said that there was such a general right, or there should be a general right, in cases which were being tried summarily in the interests of fairness and in the interests of justice. But this meant that there were two clashing decisions, and seeing that there were two different judgments from the High Court, Judge James Paul MacDonald of the District Court, he felt it was important to state a case to the High Court to see, did he have a requirement in this particular case to order that the prosecution reveal more information about their evidence. Now, Paul Amuraku at the time had a an apprentice called Maureen Moynihan. This would have generally been an issue that I would have been discussing with Maureen and with Pole as well about how the law might develop in this area. Should we have more information? And I think particularly in child cases, they are quite different as well to even adult cases, because taking information or taking instructions from a child as to what may have occurred, children, have a different experience or they can tend to not be as clear in their recollection as well. They're living in a moment and going from moment to moment. And having more and more information is so much more important. I certainly felt at the time, having worked quite a bit in the juvenile courts.
But Gary Doyle was kind of the breakthrough case. And when one looks at the effect that it has had, one only needs to look at the facts of Gary Doyle itself. The notion that you would have somebody charged with 4 burglaries and the guards didn't even take a note of the conversation with the injured party is something extraordinary for us now. And it's 32 years ago. And there's a book by Nell McCafferty called In the Eyes of the Law. She wrote these wonderful anecdotal descriptions of cases in the district court in the Bridewell in the 1970s. And reading that now, it's a shocking indictment of a criminal justice system that was deeply misogynistic, corrupt and anti-poor people. And we read that now and we think, my God, we don't live in that world anymore. But even going back to the 90s, to Gary Doyle itself, it strikes me as a case from a different world. It just wouldn't happen now.
But a lot of the things that we take for granted as our legal rights had to be argued by somebody and had to be decided by some judges and come into being and accepted as rights. And what happened then was, as I was relatively junior at the time and as we were going to the High Court, we looked for an experienced senior barrister. We asked a man called Brendan Grogan, who had acted mainly in criminal cases throughout his whole career, and he came in and ran the case in the High Court. So what happened next was a case dated. It's a formal process. That case dated is a mechanism by which a judge of the district court can really get a legal opinion from a High Court judge. It's actually quite an unusual situation, because normally cases get to higher courts on appeal, and we don't have a situation where a judge can ask an opinion. But this judge was asking really the opinion of the High Court as to what the law was. He really asked 2 questions.
Number 1, where an indictable charge is being disposed of by way of summary trial in the district court, is there a general obligation on the prosecution to furnish on request the statements of the proposed witnesses for the prosecution? Question 2, if the answer to question 1 is in the affirmative, does such an obligation extend to a case where no statements of witnesses have in fact been taken by the Garda Síochána in the course of the investigation of the offence charged against the accused?
And in the High Court, Mr. Justice Gagan actually held that there was no general obligation to give these statements. But he went on to say that it was a matter of justice and fairness as to whether one might get them. And he also said that in a situation where no statements had been taken, you were entitled to information.
The High Court pretty much said, look, you've waived all of these rights in exchange for having a summary process with a limited sentencing limit. So, sorry, you don't generally have a right to that.
So after that, we had to consider whether we would appeal or not. And obviously, without going into instructions or anything like that, it was decided we would appeal to the Supreme Court for greater clarity. So the case ran in front of the Supreme Court. Ms. Justice Denham, as she was then, later became Chief Justice, she gave the main decision for the Supreme Court. She gave quite an interesting decision, quoting again from State Healy and Donoghue, the well-known case, saying that in all cases, in all trials, even trials of what seem like trivial offences, even though she wasn't saying this one was, there is a requirement for justice and fairness. But she did say that these were summary trials. It was a summary offence, and a summary trial meant a trial that wasn't the same as a trial before a jury. So she didn't uphold the principle that there was a general right to have the statements in all of these cases. But what she did do was go through a list of things that had to be considered by a district judge if they were to refuse such an order. And these were things like the seriousness of the charge, the importance of the statement or documents, the fact that the accused had already been notified of the nature and substance of the offence, and importantly, the likelihood that there was no risk of injustice in failing to furnish the statements or documents in issue. So it was those 4 criteria that became hugely important later on. This case and all the others following it went back to the district court. And importantly as well, she confirmed on behalf of the Supreme Court that where no statements had been taken, information had to be provided as to what the evidence was if the other criteria were met. If you decided it was the kind of case that needed information or statements, you had to give those statements or that information.
So the answer that the Supreme Court gave in Gary Doyle, it wasn't an emphatic, you have a right to a book of evidence in the district court, in the same way that the statute says you have a right in the courts of indictment. But it did say there is a right there that the judge can determine in accordance with fairness what you're entitled to. It was momentous. I mean, it didn't break huge new ground, but what Gary Doyle seemed to do is sort of broke through the idea that this was an order that you could frequently request in the district court and is frequently granted. An order declaring that the defence has to be furnished with disclosure material, whether it be statements of the injured parties or a summary or what's in district court practice called a précis of the evidence.
I think what happened after that, and it took a little bit of time, is that the prosecution and the Gardaí just know that this rule exists. And now, once they receive the letter, that's the Gary Doyle letter, but the Gary Doyle order from the judge, they give it. So normally things don't have to come back into court for a formal order by the district court. But oftentimes, such an order can be given almost on the first day somebody arrives in court, because the judge will see that the charge is just so serious that not providing the information would be unfair or would risk injustice. You know, now we look at it and we go, of course you should have this information. And so it's not questioned anymore. But there has to be a starting point. And this really was the starting point.
Because your right to a fair trial applies to all trials. And if you're on trial for murder, you have a right to a fair trial. But if you're on trial for not having a TV licence, it's a criminal trial, which is protected by Article 38 of the Constitution. So it applies across the board now. It was all rooted in Article 38 of the Constitution, which gives a right to a fair trial to an accused, which is fundamental. And the Irish Supreme Court became very proactive in the 1960s in describing rights and creating case law that vindicated people's rights. And I suppose that's just an example of it.
I think as a lawyer, this was, superb, because it was so fantastic to be involved in a case that seemed to make a difference, not just in the case that you were involved in, which is always the central point for any lawyer, but, on a wider level to help establish some kind of principle and be seen to have thought about that and really wanted to make the difference, I suppose, because he was entitled to a fair trial, and in the end he got a fair trial because he was in a position to know the evidence against him. I feel, obviously, that it's one of the more important cases that I was involved in as a lawyer. It happened early in my career, so it certainly gave me a boost and made me want to keep going, see what other points were out there. Personally and professionally, just a really satisfying case from my point of view, where almost every day it's being cited as a precedent as to why somebody should get what is, after all, a fairly fundamental right, and that is to know the case against them. So to have been part of that with Maureen Moynihan, who went on to become a solicitor, and Paula Murrick, I just feel very privileged that I was briefed by them in the case and got to be part of the case, having been led by Brendan Grogan.
And I suppose the common law is interesting. It's built on cases that seem at the time quite novel and new, and then a couple of generations later, they appear to be very axiomatic ideas that we would simply take for granted. And for those lawyers in that case to make that case, which at the time was probably perceived by others in the legal community as being something of an ask of the Supreme Court and not likely to succeed, but they did, and they made history and they did a great job.
These two historic district court cases, Healy versus Donoghue and the Gary Doyle case, showed us how rights matter and how these rights are protected in practice. You have been listening to the Irish Courts Podcast, a Curious Broadcast production. with the court service and the judiciary. Thank you to our contributors, Judge John MacMenamin, Judge Frank Clarke, Senior Counsel James Dwyer, and Judge Aileen Donnelly.